And our attorney, Adolfo Mendez, is not here yet, but he called in just a few minutes ago, and he'll be right here. And on our agenda for today, we have him first to talk to us about the Open Meetings Act.
Just a couple minutes away, if you would hold on one sec.
Okay, we'll wait on you for that.
Okay, I'm walking right in the building now. I apologize for my time.
Okay, we'll have a big drum roll for you when you come in the door. He'll be here in just a minute. Mr. Chair. Good morning, Adolfo.
Good morning, members of the board. I apologize for my tardiness. I have a newborn at home, but sometimes things don't just go the way you expect in the morning. So I'm here this morning with our new board members on the Planning and Zoning Board. And so I'm here this morning to give a brief overview of the Open Meetings Act and to let you know that if you have questions regarding the Open Meetings Act, you can communicate with me directly about those. The Open Meetings Act is a very important statute, a very important state law for the operation of public bodies such as this one. And basically the heart of the Open Meetings Act is that public business is to be conducted in public. There are certain exceptions to some items that can be conducted in closed session, such as things like the evaluation of an individual employee, when there's discussion about threatened or pending litigation between the board and its attorney. Those are a couple of the exceptions that apply. But otherwise, public business is to be conducted in public. And as members of a board, when you act collectively. Your authority is as a board, it's a collective authority. And so whenever a quorum of you are together, there is the risk of public business taking place. So what does the Open Meetings Act require? It requires notice to the public of what will be discussed by a public body. It requires an agenda so that the public has notice about what will be discussed. And then it requires that there be minutes of that meeting recorded, and that's why you have all of your staff working on that. So things to be cautious of. When you're not at a properly noticed public meeting, such as this one, you don't want to talk about public business. It's just, I know there's a lot of, well, with each other, right? People will come up to you and say, you may try to talk about things, and you can say, we're going to have that on a future agenda, or thank you for your comment. They may have comments and things like that. But you really want to make sure that you conduct your business here at this table. So and it happens, right? There will be times where 3 of you may be at the same place at the same time. So you may have a quorum. At those points, you just want to be careful not to discuss anything that is before you or may come before you. So you don't want to discuss zoning matters, essentially, because the proper place for that to happen, for that type of discussion to happen, is here in front of the public, so that they hear what their public body is doing. So I just wanted to kind of hit those highlights for you today. If you have any detailed questions, you can always, because particular situations may come up where it's unclear as to what the proper action would be. That happens, and you can contact Steve, who can contact me, or you can contact me directly in those instances, and then I can give you legal advice as to what I think, whether or not a particular action is or is not within the framework of the Open Meetings Act. Yeah. Steve asked me to discuss a little bit about investigating something that's before you on your own. You have staff to do that for you. You have your own knowledge of the larger community, and that's why you're on this board. You have that kind of personal knowledge, and you have your personal experiences that you bring to this table. But when a particular application comes before you, you want to weigh that application based on the evidence that's presented to you. You don't want to go off and get your own, go do your own individual investigation, because then you might be making your decision not based on what was presented to everybody, but you may be making your decision on your own personal investigation. And that's information that's not before the whole board. If you require, or if any individual on the board feels that, you know what, we need a little bit more information. What I'd like to see, let me, as an example, I would like to have photographs of a fence line, or I would like to see X, Y, and Z. When the item comes before you, you get the information that's presented, and at that point you can say, you know what, we do need more. Staff, will you please go gather more information and bring it before the board, so that again everybody has that information, and so that the decision is based on the information that's been presented in an open session of this body. Otherwise, you can risk recusing yourself, because you might be basing your decision on information that is not that hasn't been before this board. So what happens if there's a violation of the Open Meetings Act? The risk is this: it can void your decision. So let's say there is discussion, and three of you decide something at a coffee shop. Let's vote this way. Okay, that's a clear violation of the Open Meetings Act. I would never recommend that happen. I would advise that never happen. But let's say that happened. And then the item comes before this body, and those three members vote that way. That would be a violation, and whatever action took place would be void. So people would try to rely on that decision. People going forward relying on that decision could be, would have a very uncertain outcome. And when it comes to land use, it's important to have clarity and certainty, because people are relying on this. People are relying on the ability to subdivide their property to go forward, for example. Or they're relying on the zoning that they have. We want to make sure that the decisions this body makes and the recommendations this body makes are solid and are not subject to that kind of challenge based on violations of the Open Meetings Act. And willful violations are where that means there was an intent, a purpose, and someone did it on purpose. Those can subject board members to an individual liability as well. When there is an intentional violation, like let's not put this on the agenda, or let's, that kind of intentional, like, yes, let's go meet privately without anybody around, that type of willful violation is the type that, in my opinion, the Attorney General's office would really get involved in. So, very important to follow the Open Meetings Act. If there are questions, please ask. But the gist of it is notice to the public. Public business is conducted based on an agenda. It's conducted in open session here, and then it's recorded by minutes. If you have any questions now, I can field them. Otherwise, feel free to.
I have one or two. We have a board of 5, so 3 is a quorum.
Correct.
So if Red and I want to talk about it in the coffee shop, we could. But I also have a comment that would be legal, as I understand it. But public perception would not see it that way. So I think it's best, even for 2 of us, not to discuss.
I think that's wise. That's a wise approach, because there's another risk. Let's say the 2 of you, let's say the 2 of you talked about it, and then one of you talked to one other person.
Right.
All of a sudden, you have what's called a rolling quorum.
I understand.
And it wasn't a quorum at that one instance, but because the same issues were discussed, like I talked to him and he said this, what do you think? To the third person, you have now created a rolling quorum, and public business has been discussed outside of an open meeting.
Thank you for that thought. Any other questions? Could I ask you a question on something else?
Certain.
Going over our format, I know that at the county commission meetings, they have a 2-minute limit if someone from the audience would like to bring up something. And we do not have that on our format. But we do have some people that would like to speak for 2 minutes on a subject that's not on the agenda. Is that allowed, or is that against the Open Meetings Act because it's not on the agenda?
Discussion
I
items
can-
are further down on your agenda.
There is an agenda item for discussion items where no decision can be rendered. So at the
Oh, I
moment,
see that.
at the moment where the board approved the agenda, a member of the board could say, I would like to discuss such and such subject. No decisions can be rendered, but I would just like to bring it up. And that could be placed at that point in time. And at that point in time, if there's members of the public that the board would like to hear from about that discussion item, then that would be the appropriate time to do it.
So is it all right for the public to bring something up if they want to do that?
There is, I think it would have to come from the board, because there isn't any public meeting or public comment part on this agenda. So within that discussion item area, a member of the board could basically create the item for the public to speak under, because there isn't anything for a public comment period. I will say this, because we're talking about it, the Open Meetings Act does not require the public to have the opportunity to speak at meetings. The Open Meetings Act requires that the public have the opportunity to attend and listen. So when they're public, so it is the board and it is the agenda that creates that that space for the public comment to speak.
So they could speak by invitation from one of us.
Yes, on this agenda. If there were an agenda item that said, public comment period, you can talk about anything for 2 minutes, then it's on the agenda. Otherwise, there's no notice that anything like that would be happening.
There has been, since I've been here, just like very few occasions where the public wanted to address an issue to the board in a discussion, where they were able to do that if they were on the agenda ahead of time. But just for walking in and speaking that.
Right. And that's a good point. An excellent way to address those types of things is saying, let's put it on the agenda. That, let's say a member of the public approaches a board member and says, I want to talk about this. And that person weighs in and says, you know, that is an important issue that should be spoken about here. Put it on the agenda for the next meeting, because then the rest of the public has noticed that that's an issue, and they can come and they may have something to say. So that's actually a more open way of doing it, is by saying, okay, that's an issue we want to discuss. Let's place it as a discussion item, and let's let the public know that we're going to be hearing that information.
And that way they could have a little more time to speak, probably.
They could have more time to speak because there would be an item before this body, and other members of the public would know that this body would be hearing that kind of information, and they may have something else to say. And so they would have, those people would have the opportunity to come and say their piece as well.
Okay, good. It's good that you tell us some of these things, because now we're mostly new on this board. That's good information.
Right.
Good information.
Yeah, and that was the idea, because whenever there are new people coming on the board, Steve always gives me the reminder, give them the Open Meetings Act talk. So, because it is the state law that governs these types of meetings. It's kind of the umbrella. They call it a sunshine law, that public businesses conducted it in the light of day and not in back rooms.
Good. Well, I appreciate all you had to say, and I know we all do. And thanks again.
Appreciate it. And again, sorry for the late. I'll take my place on that side.
Very good.